I, Prachi Bhardwaj, Senior Associate Editor, EBC. I'm thrilled to welcome you all today as we gather here not to just to celebrate a book release, but also to embrace the masterpiece that has revolutionized our understanding of company law. Dr. Avtar Singh's Company Law, a title that resonates with authority and insight, is here with its 18th edition. This isn't just any edition, it's a game changer, with significant updates reflecting the latest amendments to the Companies Act, along with pivotal judicial precedents from the tribunals, high courts, and the Supreme Court. This book is your ultimate compass in the intricate world of company law. So let's ignite this celebration by welcoming our esteemed guests. Please join me in welcoming our chief guest today, Justice Hrishikesh Roy, a towering figure in the Indian legal landscape. From his beginnings as an advocate to shaping national jurisprudence as a judge at the Supreme Court of India, Justice Roy's journey is nothing short of remarkable. Justice Roy is not just a jurist, he's an innovator, with a passion for law that even extends to filmmaking with projects like Shako and Apne Ajnabi promoting ADR and legal aid. His tenure is characterized by transformative decisions that enhance judicial efficiency and advocate for social justice. And who could forget the delightful tale of how a conspiracy between Justice B. Sudarshan Reddy and Justice Roy's wife paved the way for his judgeship. It's the only conspiracy that both the bar and the bench wholeheartedly support. Although initially reluctant to take up judgeship, Justice Roy has never been a reluctant judge, which is evident through his judgments. We are honored to have you here as our chief guest today, sir. I would like to request Ms. Nilufa Bhateja to felicitate Justice Roy. With an impressive over 25 years of legal expertise, our next guest, Ms. Haripriya Padmanabhan, stands out as a beacon of excellence in the legal community. Last year, she was one of the 11 women advocates designated as senior advocates by the Supreme Court, a testament to her unwavering dedication and exceptional skills. Specializing in commercial, constitutional, and civil law, Ms. Padmanabhan is not only a fierce advocate, but has also acted as court-appointed mediator. Since embarking on independent practice in 2008, she has made significant strides in insolvency and bankruptcy cases and commercial arbitrations, areas that ignite her passion and commitment to justice. We are honored to have you here with us. I would like to request Mr. Aditya Gupta to felicitate Ms. Padmanabhan. With over 20 years of extensive experience in mergers and acquisitions, joint ventures, corporate restructuring, and general corporate advisory, our next guest, Ms. Akila Agarwal, has established herself as a leading authority in the legal landscape. Ms. Agarwal's impressive track record is complemented by her considerable national and international experience, having successfully represented numerous significant clients across diverse industries and sectors. Her exceptional contributions to the field have earned her consistent recognition in prestigious legal rankings. We are honored to have you here with us. I would like to request Ms. Kriti Kumar to felicitate Ms. Agarwal. Our moderator, Mr. Vishwajit Chaudhary, is a distinguished legal mind whose journey began at the University of Kent, where he earned his law degree. A proud barrister at law from the Honorable Society of the Inner Temple, Mr. Chaudhary further honed his expertise with a master's degree from the prestigious University of Cambridge. While Mr. Chaudhary practices in the Supreme Court and Delhi High Court, he is also door tenant at Lamb Building, a London-based barrister chambers. Beyond the courtroom, he is an avid traveler, a dedicated reader, and a lover of horses. We are excited to have you here with us as a moderator today. I would like to request Ms. Deeksha Dabas to felicitate Mr. Chaudhary. Our first revising author, Mr. Siddharth Raja, is a seasoned corporate lawyer with nearly 3 decades of experience, currently serving as a senior partner at Vertices Partners, a prominent pan-India law firm. He is also a solicitor of the Law Society of England and Wales. He has co-founded 3 commercial law firms and specializes in company and corporate law, private equity, venture capital transactions, and cross-border mergers and acquisitions. He is also a certified commercial dispute mediator. In addition to his legal practice, Mr. Raja is passionate about academia, teaching at various prestigious institutions. He is actively involved in public lectures on corporate law and has diverse interests, including historical research and heritage tourism through his company, Nandi Valley Walks. We are honored to have the 18th edition of Dr. Avtar Singh's company law revised by you. I would like to request Ms. Tejaswini Mishra to felicitate Mr. Raja. Our next revising author, Mr. Dharmendra Chatur, is a dynamic first-generation lawyer with over 12 years of expertise in cross-border and domestic dispute resolution. As a partner at Poovayya Co, a leading full-service law firm in India, he has successfully represented clients across various sectors, including banking, healthcare, technology, corporate and commercial law, IP, white-collar crime, and more, with litigation experience in multiple jurisdictions, including India, UK, and the US. As accomplished academic, he has served as a visiting faculty member at the NLS Bangalore and Christ University, and has published extensively on topics such as insolvency reforms and arbitration. We look forward to your invaluable contributions to the edition. I would like to request Ms. Shubhra Venkat to felicitate Mr. Chatur. Our next revising author, Ms. Saranya Mishra, is a dynamic transactional and corporate lawyer with over 6 years of experience. Specializing in high-profile mergers and acquisitions, regulatory compliance, and corporate governance, Ms. Mishra has carved out a niche in advising clients on complex governance issues, including related party transactions and corporate social responsibility. With over 70 publications on corporate governance and legal innovations, Ms. Mishra is also a passionate advocate for diversity, equity, and inclusion. She also actively engages in pro bono work and mentors aspiring lawyers, fostering the next generation of legal talent. We look forward to your contributions as a revising author to this book. I would like to request Ms. Sonali Ahuja to felicitate Ms. Mishra. Founded in 1942 by 2 young brothers, EBC, since its inception, has been at the forefront of delivering high-quality legal resources to both professionals and students. In an ever-evolving legal landscape, EBC stands as a vital link between the law and those it serves, fostering understanding and accessibility. Mr. Sudeep Malik, as a director at EBC and associate editor at SCC, leads a dedicated team that is committed to delivering what is arguably India's most trusted law report. With a commitment to excellence, Mr. Malik is steering EBC into a new era of innovation and reliability in legal reporting. Thank you for joining us today, sir. I would like to request Mr. Taha bin Tasneem to felicitate Mr. Malik. I would now like to request Mr. Sudeep Malik to welcome the audience with his address.
Good evening, everyone. It's really a lovely collegial atmosphere over here. It is my great honor to welcome our chief guest, my Lord Justice Hrishikesh Roy. Such a pleasure to have you with us. Ms. Haripriya Padmanabhan, senior advocate. Lovely again to have you here. Ms. Akila Agarwal, senior partner, Cyril Amarchand, Mangaldas. Mr. Dharmendra Chatur, welcome. It's lovely to have you here. And Mr. Siddharth Raja, whom I've known for such a long time. It's such a delight. And to hear all the things, especially your love for teaching, is something very heartwarming. And welcome, Saranya. And I'm sure everyone knows that Saranya is a student ambassador of EBC, par excellence, and emeritus member lifetime. And our most wonderful moderator, who I'm sure will be leading a rather exciting discussion today. So it's rather nice that we are in this collegial sort of, I was almost taken back to my first and only lecture of corporate law in Cambridge, because I fell off to sleep and I decided that this is not something where I'm going to learn very much. And that's unfortunately because in England they don't have a book like company law, because this book has been authored by a teacher. And it's the same spirit which is beautifully exemplified in this revision. And in fact, I'd just like to read a couple of things from the introduction to this book, which sort of puts it very much in perspective and what this book is really about. Now, this is my experience in that one and only corporate law lecture. It says, the company law can be daunting as to its apparent staggering complexities, as well its undoubted sheer scale and range of materials and sources. And at that point, England was still a part of the EU, so not only did you have all of English law, their statutory material, and you had to also do EU law. So you will commiserate with me that I fell off my chair because I fell asleep and I thought this is too much detail. But what sets this book apart and the approach, and this really warmed the cockles of my heart, because I also had the privilege of teaching law for 6 years at the National Law School in Lucknow. And this is exactly what I had tried to do over there. And I'll just read out. It just couldn't be said better. He says, what this book seeks to achieve is create an outline of a foundational framework for legal analysis in the area that is company law. In other words, it aims to construct the several sinews of a legal method, namely a general outline of a body of skills and techniques which will enable the student to distill and dissect the company law as to its essential principles and in law, and thereby, most importantly, dissect those principles and apply them to real-world situations or academic testing. I mean, that's what legal teaching should be all about. I remember when I was in school, and since I've been with so many of the people here while my brother was in law school and I was just a student in school. So I asked him, so what have you gone and learned? You know, the first time he came back, they said they're only going to teach us two things. One was how to find the law and how to think like a lawyer. I said, really? 5 years you're going to do just that? So that stuck in my mind because I was, I think, in class 9 or 10, and you know, when your elder brother goes out, he's the first person in that generation to go to college, so it sticks in your mind. But so many years later, and I used to start my lectures with this statement, though I added a half to it. I said there are 2.5 things. One is to find the law, think like a lawyer, and the half is the essential foundational principles. It's exactly the approach that we have here, and exactly the approach that they did not have in Cambridge towards company law. Right? So I did not, unfortunately, study that subject there. And this is precisely what is so wonderful about this book, and certainly as he puts in his conclusion, and I'm sure speaking for all the authors, this is going to make company law so much more exciting, because the detail and the complexity is staggering. The sections can go on for half a page and so on, and obviously they don't know what a sentence is. They're confused between a paragraph and a sentence. So, you know, you need to rethink your grammar. Ye sentence hai ki ye paragraph hai. You know, it just sort of... So all that suddenly comes alive when what you want to do is cull out certain essential principles so you can think like a company lawyer. And what does it mean to have those instincts? And this would have particularly pleased one of those two boys who set up EBC in 1942. An interesting story here. So one of them is Chunni Lalji, who is the elder, and the other is Prakash Lalji. So Chunni Lalji was the one who sort of traveled around India, meeting authors and creating so many of the books that we know, and Dr. Avtar Singh, 18th edition. I mean, that's quite a feat, quite an achievement. So very early on, because neither Chunni Lalji nor Prakash Lalji, they were not graduates, and they were certainly not sort of lettered in the law. So they meant by instinct, and so they really kept the company of as many of the academics there were in Lucknow, because the Lucknow University was very active in law, and so we have so many great authors from that time. And sometimes those authors used to walk in to our large showroom in Lucknow. So one day, one of these professors walks in. This must be in the early 50s, the very sort of inception of EBC. He walks in, says, he looks at some of the student books and says, Chunni Lal, ye kya kar rahe ho? So he's so startled. Because he said, what do you mean, main kya kar raha hu? He said, what is this? So he says, what is this? These are student books. He said, no, these are not student books. Ye kunji hai. These are keys. This will destroy scholarship. He said, really? He said, I didn't know. He said, yes. And you know what he did the next day? He got the entire stock, had it cut and sold in Raddi. Because he said we have to develop real scholarship. We have to have true books, which, I mean, from that day, the idea has been that we develop genuine Indian legal scholarship, because after all, legal education is everything to the legal system. If we have lawyers who can do those two things, think like a lawyer, find the law, I think we are home and dry. So I lead you on now to this wonderful discussion, which is exactly, I think, on this issue. And again, a very warm welcome to everyone, and let's have a very interesting evening. Thank you very much.
The moment that we have all gathered to witness has arrived, and I would like to request Justice Roy and all the dignitaries to unveil the 18th edition of Avtar Singh's Company Law, a book destined to empower, enlighten, and elevate the discourse in our legal community. I would also like to request Mr. Sumain Malik and Mr. Sumit Malik, directors EBC, to join in. This deserves a big round of applause. Keeping the momentum on, I would like to invite our chief guest, Justice Roy, to please address the gathering.
Friends, I would like to speak about another Chunilal ji who happened to be in our part of the country. I come from Assam, when I just commenced my legal career. The gentleman's name was Mr. Gogia, and is to represent the interest of the Eastern Book Company in the Northeast, basically Guwahati. Now, as a young person, not earning much, you will think and weigh which book to purchase and which to defer for now. And his comment was that books, Mr. Gogia's comment, books, particularly law books, are one of the few things you can buy that will make you richer. This is what he said. And I do remember that you buy your constitution, you buy your IPC, you buy the usual CPC, etc. Now you will think a little more whether to buy the company law book by Dr. Avtar Singh, because you are not expecting any litigation to come. He'll say, le lo, paisa jab bhi hoga de dena. But as he said, that when you buy books, particularly law books, you will always become richer and not poorer. This is a lesson that I have taken from that another Chunilal, if I may say so, Mr. Gogia, who was representing the interest of the Eastern Book Company. Now, the first edition of Company Law by Dr. Avtar Singh, as I noted, was published in 1966. We go back a long time. I graduated from Campus Law Center, Delhi University, and entered the legal profession in 1982. And my introduction to this very dependable book on company law was perhaps through the 7th or 8th edition. I'm not too sure about that. While consulting the older edition in the 1980s, I immediately realized that Dr. Avtar Singh's book was a dependable law book, which lucidly explained the key principles of company law. No wonder Mr. Arvind Datar, the senior counsel, in his introduction to the 18th edition, said the following, and I quote, after started practice, this book continued to be useful, particularly for the references to English cases, which were not there at that time in Ramaya's Guide to Companies Act. While I was arguing a winding up petition in 1984, I found that Ramaya did not contain few judgments which were there in Dr. Avtar Singh's book, and had also not considered certain Indian judgments which were in the AIR manual. I wrote to Mr. K.K. Wadhwa, the then publisher of Ramaya, about the missing cases. That then led to my being invited to be on the editorial panel for revising Ramaya from 1989 till 2004. I revised Ramaya's commentary, which was section-wise and therefore had not initially referred to many important English decisions. Thus, the initial reading of Dr. Avtar Singh's book proved invaluable in revising Ramaya as well. Now, these are important words by somebody who we all respect, Mr. Arvind Datar. Now, on this publication, in his special message, the senior counsel, Sergeant Poovayya, said that Avtar's company law has long been a foundational text for Indian law students and professionals alike. I think he made some very important comments there. I must also endorse the message of Mr. Ravindra Jhunjhunwala of Khaitan and Company, who wrote that Avtar Singh's company law will continue to be a trusted guide for anyone embarking on their journey to understand the intricacies of company law. Besides acknowledging the efforts of Dr. Avtar Singh in penning down the commentary on company law, which has already traversed 17th edition, I must compliment the editorial team of Siddharth Raja, Dharmendra Chatur, and Saranya Mishra. People have spoken so highly of you for their scholarly work in revising and presenting the 18th edition of the classic work on company law. When I was leafing through the book, I could not help noticing the masterful introduction written by Siddharth Raja, who as a seasoned corporate lawyer with decades of experience had added immense value to the book and made it very useful for the reader. I must compliment you on your lengthy introduction. It is also seen that several key chapters in this book are authoritatively composed by advocates Dr. Chatur and Ms. Saranya Mishra, and they deserve our acknowledgement. Dr. Singh possessed the remarkable ability to present intricate legal concepts in a manner that was both scholarly and easily understandable. His writings stand out for their simplicity, which easily captures the reader's attention. This book over the years has long served as the first point of reference for law students. They also continue to be cited, respected, and referred by practitioners, academicians, and even judges. The 18th edition of company law comes at a time when the corporate landscapes of India is undergoing significant transformation. And Ms. Akila Agarwal would be, I'm sure, speaking on this. With increasing regulatory oversight, the rise of startups, globalization of Indian companies, and the growing emphasis on environmental social governance, I have not understood this term, and corporate governance, there is a renewed need for legal clarity. This edition not only reflects the latest legislative developments, including amendments to the Companies Act, significant judicial pronouncements, but also upholds Dr. Singh's signature tradition of lucidity and scholarship. I have often maintained that a good legal book does not just inform, it educates, inspires, and endures. Avtar Singh's Company Law is one such book. It has shaped the intellectual foundation of countless lawyers and judges, and I dare say many of the sharpest legal minds in our courts today are likely to begin their understanding of corporate law with this very textbook. The present edition contains substantive and incremental changes over the last edition. The changes reflect the amendment in the statutory regimes governing companies, more particularly the 2019, 2020, and 2021 amendments to the Companies Act 2013. In addition, the changes also reflect judicial precedents starting from the National Company Law Tribunals and Appellate Tribunals, the High Courts, and the Supreme Court. The revised edition shows that the contents of the book had been significantly restructured, principally by organizing the various chapters into more logical order, presenting a streamlined flow of legal principles, statutory provisions, especially delegated legislations, and judicial precedents, both within the concerned chapter as well as across chapters. My warmest congratulations to Mr. Siddharth Raja, Mr. Dharmendra Chatur, and Ms. Saranya Mishra for revising and enhancing the quality of this timeless text. The publishers, Eastern Book Company, and the team Malik deserve thanks for preserving and for ensuring that the legal torch lit by Dr. Singh continues to burn brightly for future generation. I'm sure we are in for an exciting maybe half an hour or a little bit more than that from the esteemed panelists who are here present on this occasion with the moderator. Thank you.
Thank you, Justice Roy, for your encouraging words. I would now like to request Justice Roy and Sudeep sir to please join the audience and witness the engaging panel discussion. Today we explore a thought-provoking topic, corporate law practice versus academia. Where shall the twin meet? The discussion will examine the dynamic relationship between practical legal application and academic theory. And our moderator is quite excited to take the discussion forward. So over to you.
Good evening, everyone. It's an absolute pleasure to welcome you all. And I think it is great that we are all here to talk about this book. I think my lordship has already tied down the time to about 30 minutes or a little bit more in his characteristic style. So we will try sticking to that, and it's on the panelists more than the moderators. But I think two things that stand out about this book, and I think the first is how enduring of a name it has been. And as my lord said, since 66, and we are in 25, and it still is probably the book to go to for affairs on company law. So there's something that's definitively very special about this book. And I will be asking a few questions with a few minutes in the end for the audience to ask any questions. So please do scribble them down. And in case you have any questions towards the end, please do ask the panelists. So one of the things that I will begin with is, as I said, it has endured generations, and it has been a continuous favorite between students, academics, and practitioners. And I think the panel also reflects that, where we've got people, very, very accomplished practitioners. We've got accomplished law firm experts as well as academics. So my question, I'll probably begin with you, Siddharth, to ask you about what is the motivation behind this exploration of the relationship between corporate law and practice? What motivated that sort of sense in that direction?
Yeah. Hey, thanks so much, Vishabji, for that. Thank you, and for those introductory remarks. Very, very nice indeed. It's very simple. I'll come straight to the point. Company law is one of those, it's part regulatory, part constitutive. It's not like, if you look at the contract law, where ultimately negotiation, whatever you might agree, can modify the rule, is partly regulatory, but partly determinative. So, like for instance, the idea of limited liability, right? But at the same time, you have a plethora of regulations, which is black and white law. But that, I think, is something. I mean, not sure if it is the only law that would stand out like that, but it's such an important law because, as I also mentioned in the introduction, every transaction is involved in some corporate structure, the idea of the limited liability entity, right? And so it's absolutely essential to understand how companies operate. I should just mention one thing else in passing. I was just mentioning to Akhila, actually. There was a point in time, and if you look at it, and a little bit of I like to look at these things historically. There was a point in time in this book's progression where it started to get, the principles started to get drowned out by the sections, right? It started to go towards what Ramaya is to the practitioner. It's essential to know the section-wise analysis because you get all the cases and the rest, right? But, as Mr. Datar was mentioning, in some cases things are missing. But it began somewhere at the time when I was in law school, where it became a little too section-heavy, right? Where it started to flow like the statute, which is not what it used to be. It has to flow according to principle, and we've tried to claw that back. I think, it's a tough ask. It's an extremely tough ask to do because it's so easy to just slip into what section this and section that says.
Absolutely.
And to pull it back. In fact, and I'll end on this and I'll let you talk more about how the development of this book and the theory comes along. is that when we were in law school in the 90s, and many over here will echo this thought, our company law professor used to be pretty dismissive of this book.
Right.
Used to say, as a little guide. It's like, those guides that you get, to study for exam. Because he felt that it was becoming too section-wise rather than principle-wise. Of course, he had this, to some extent, a colonial hangover, maybe,
Right.
Gower and Palmer and all of that. So, so there was that sense. But I think there is some truth, right? Nothing is ever black and white, right? So he had some point that it became too, it started to read like the statute rather than like the principles that it should draw out. I'll stop at that. Thanks.
That's very, very helpful. And I think it's just going on to prove that NLS has its share of Cambridge-like professors, who would not necessarily do justice to the subject. But I'll move to the second author. Ma'am, wait for the final. No names. Right. If I may move to you, Dharmendra, and you could also elaborate on that distinction between corporate practice and law.
Interestingly, the professor that taught Siddharth, his student was my professor in law school. So she had the same colonial overhang. And when we were in law school, obviously, Avtar Singh was looked at very dismissively. We were asked to go look at Palmer, Pennington, and Gower, and so on and so forth. And that obviously is one way of studying company law. It's looking at additional text. It's looking at how those professors and that jurisdiction has, at least it trains its students. But I think our intention, at least Siddharth and my first conversation 4 years ago almost, on rewriting this book was to sort of move in that direction.
Right.
It's a job half done right now, but it's something that we're planning to continue on with the next edition and the editions after that, because it's very difficult to claw it back, to pull it back, to sort of synthesize it into its bare principles, because that was what I learned, at least at U Chicago, because having studied in India and then going to U Chicago, where it was completely principles based.
Right.
And that's, I think, a far more enduring way of looking at legal subjects at a foundational level, rather than just saying this section says this, that section says that. So that was something that was our takeaway from that.
Right. Thanks very much. We will not be bringing any more professors into the conversation. And with that, I move to you. What would you like to add?
I think in terms of my background, I hear both my co-authors talk about what they heard about Avtar Singh in their law schools. Now, the thing is, I didn't pay much attention to corporate law in my law school. And a testament to that fact is that I assisted Dr. Sanjay Jain, who was editing VD Mahajan at that point of time. So I was an out-and-out Consti kid. But then came a law firm PPO, and then came corporate by design, not as much of a choice. And then this happens. So I don't really have any hard and fast rules of what my professors had to think, and I don't think they had any thoughts in place. Because for them, literally contract or company, Avtar. And, of course, Kelkar and Takwani for the rest of the procedural laws. So, and I think I kind of made sure as a student ambassador that they don't stray away from the path. So, yeah, I think that being said, on your very categorical question on where do we see the delta between the corporate practice and what is taught in law school is the commercial acumen. Because a lot of times, you're speaking to the client is not asking for the academic answer, can you do this? Something as simple as, can a CFO with no degree can be appointed, no finance background, can he be appointed? Now, technically, there's no eligibility requirement. So would you tell your client, no, just appoint anybody, because there's no eligibility requirement. But in today's day and age, you think of NRC liability, CFO ka own liability in terms of, signing off on something like CSR spend, signing off on the financials, running point on it. So many responsibilities that lie on the CFO. So then the commercial acumen then that sets in is to say that technically this is a requirement, but, commercially, if you think of it from your reputation perspective, these are the things that you should consider. So, and I think that really lags behind because, as everybody mentioned here, the teaching is a lot more theoretical and it tends to run section and chapter-wise than concept-wise. So, yeah, over to you.
Thank you very much. May I, same question to you, ma'am, Akila ma'am. Would you? No, but what's the disconnect between corporate practice and I am hoping you read the book at some point. And academic law.
Corporate practice and academic
Yes.
teaching, yeah. So I think Saranya just proved it, that you can be a very successful corporate lawyer by not attending any of the corporate law classes. So there is...
The reverse is not true.
the reverse is not true. Knowledge is power, I suppose.
Right.
But there is no disconnect. I wouldn't say there is a disconnect, but
Right.
of course, there is only this much you can learn in law school
Absolutely.
due to paucity of time. And that is where books like this are really helpful, and it helped us because it lays the foundation.
Right,
Sumit Malik, who was 462 and I was 463 in law school,
right.
he has picked up with very limited attention to classes the two guiding principles of knowing where to look, whom to ask, how to find. So that is
Right.
all practice is about. And so I wouldn't say there is a disconnect, but it is good to have a good foundation. And in Companies Act or corporate law in general, those principles, whether it's fiduciary duties, minority protection, or limited liability, those are very hardcore principles. So no matter how much the practice changes, if your understanding of those fundamental principles are good, you would be able to deliver, more sound advice for your clients. So.
Right. That's very helpful. I should also add a disclaimer that please do read your books to all law students watching. And to you, ma'am, would you like to add something?
No, about disconnect, I think I agree with Akila. There's very little time in school, so you can't even hope to achieve even like 1/4, 1/10 of what company law really entails. So I think it's too much to expect, right? Number one. Number two, dealing with what Saranya said about, the basics about what has to be done if you needed X, Y, Z done. Actually, there is an entirely different study for that, which is the company secretary practice, right? So for a long time, you had company lawyers who were also company secretaries, like, for example, my own father. And I think that was his USP. So if anything had to be done in a company, the procedure is there. You have an entire book, a commentary, I think even ABC has, on company secretarial practice. So what form do you need? What you need to do if once you hold a board meeting? What is an agenda notice? All these practical aspects are actually more than corporate law. It's corporate secretarial practice, for which there's a separate course, separate study, and at one point of time, we had separate professionals.
Right.
Now, of course, all of us, because of cost cutting, all of us want to do everything, because we don't want to have a separate CS and a separate company lawyer. Yeah, and having said that, I think Avtar Singh is great. I think Palmer and Grover are highly overrated, because when I'm in a hurry and I need to research, Palmer and Grover are absolutely useless.
Right.
Because I don't want their opinion, I want to cite a judgment for court. And I will use Avtar Singh only, and possibly Ramaya for a more detailed discussion, right? And any esoteric discussions on topics we can have without recourse to these books.
Absolutely.
So I really think Avtar Singh has a special space in my life. I've studied my company law in school. And even now when I do matters, I would love to look at an Avtar Singh, because I get my research done much quicker. When I want to get into a debate or a discussion, I will read Palmer and Grover. But otherwise, this suits us. I think if more people read it, we'll have better corporate law judgments.
Another disclaimer. Right. Thank you very much. In fact, I'm going to begin with in reverse order with you. I think one of the things is that rule of law demands that there is, of course, efficiency, there's transparency, there's also fairness, but it also needs a defined certainty and efficacy. And I think, especially in this area of law, in that regard and to that extent, how do you think that the corporate structures, including the tribunals and other corporate structures, the company law tribunals, how do they function and how do they match up to the demands of the rule of law on the one hand and how they perform?
Actually, there's a huge disconnect there. And I think that also is there's a larger issue on tribunalization itself, over which some of us practicing lawyers have a very strong opinion about how these were taken away from the high courts and given to tribunals. And while it's great that there are tribunals in space, I don't think necessarily all of them are breaching that gap and are fulfilling the functions in terms of speedier justice, quicker justice, specialized justice. I don't think that's really forthcoming from most of our tribunals, number one. Number two, again, the same problem of any judicial vacancies there in our tribunals today. There's a huge vacancy. And today, with the advent of IBC and winding up having been taken away from high courts, our NCLTs and NCLTs are overwhelmed with IBC cases. If you file an operation mismanagement or something simple like saying that, I want to change my ROC address, that matter will take 3 years because they don't have time to hear those matters. They take overwhelmed by IBC because there's strict timelines, because you have your superior courts which come down heavily on you if you don't, meet those timelines. So today, I think we have an insufficient structure. And of course, a favorite topic of mine, we have in NCLAT today, we have about 9 members over the last, 9 years. We've only had 1 woman NCLAT judge. And in NCLT, there are 60 NCLT members, of which there are only 10 currently as members of NCLT. And the last 10 years, we've had 11 additional ones on the side. So I think as far as gender is concerned, it's highly disparate. Number of tribunals, highly disparate. They're completely overwhelmed with work. And when you need to push a matter and you say it's urgent, they just don't have the time. I mean, I feel sorry for the members. I'm not saying they are to blame. The system is to blame.
Thanks very much. Would you like to add anything, ma'am?
Yeah, as in, I think it's a 10-marker question, but I'll answer in one mark as to, the issues we face with the NCLTs. So as practitioners, the biggest problem that I face is I'm never able to give my client any assurance on timeline or outcome. So we are completely, at a back foot when advising clients. And this becomes very difficult when you're doing transactions which are value dependent. So how can I do a merger when the merger is going to take 10 months and the whole world would change upside down by the end of that 10 months for the same value? So these kind of questions, I wouldn't say whether it is a tribunal or the court, so I don't have a very firm view on that. But I think the justice delivery process in terms of company restructuring, whether it's a winding up or an amalgamation or a demerger or a reduction petition, if you look at comparatively with other jurisdictions, so we do a lot of global transactions. There'll be 25 countries on the chart as to how something can be achieved. India will be the only one which will be red for the longest time, because in other countries, a merger can take place by contract. It could be done over a period of 2 weeks, but we take 9 months, and even that's not assured. So I think there is something needs to be done about the way we are functioning, because if you really look at all our merger petitions, there are notices sent to the income tax authorities, notices sent to RBI, but nobody responds. So at the end of the day, it is just a paper application, lawyers draft it, councils make money, and then they go and argue. There is no public policy element which is really discussed at length. There are, I think, only 2 judgments which say that this merger is rejected because of public policy. Whatever valuation comes, if it is a normal intra-group kind of an amalgamation, nobody questions the valuation. So why take 9 months to bless something which could be done in 2 years? So my grouse with, it's not the tribunal, but it's the entire process of restructuring.
Thanks very much. Siddharth?
And I just wanted to just draw very good insights on the practice of it. I just want to draw it back to what a book like this might be able to do, right? And, look at some of these things that I have seen, while doing some courses on company law, right? Fundamental things that directors discharge a duty, boards have act, right? Directors discharge, boards of directors act. Something as simple as that, right? Is lost in all of this. Now, if people were, and I'm saying this in the context of your question, if we had better draft, I'm only suggesting, maybe provoking a debate. If we had better drafted petitions, right? I'm not blaming anyone, please don't get me wrong. I'm not at all saying anything. All I'm saying is that this, and of course, my other pet subject is we've lost, me included, have lost the ability of writing in plain English.
Right.
Yeah. That is really, if we had that kind of at law school communicating this.
Crisp.
You know, to crisp, being able to understand how boards, for example, in this issue of mergers, right? What's the role of the board, you know, in the sense of a discharge of an authority, of a function?
Okay.
What are individual directors' duties vis-a-vis the merger? Right? These are all fundamental questions, right?
Right.
And then you go into, when you start making the filings, etc., what is your responsibilities there? And then you get to the procedural requirements.
Right.
You know, are you filing in accordance with XYZ rule and things like that, which also has consequences back on the board and the directors, right?
Correct.
And, well, shareholders, as my old boss used to say in those, when we used to have this suddenly struck me, we used to have a piece of legislation, many would have forgotten it, called the Sikh Industrial Companies Special Provisions Act, right? Sikh companies. Companies went sick, right? He used to always say, companies go sick.
Okay.
Promoters never fall sick. Right?
I'll come back.
You know,
to-
anyway, so my
I'll-
point is,
yes.
I'm my only point is that if that, coming back to the book and the idea of just integrating better teaching in
So it starts at
corporate
the
law.
source.
By the way, the other, and I know I'm now getting ahead of myself.
Yes.
Corporate
Yes,
law.
I'm going to stop
Corporate
you.
law versus. Okay, sorry.
I'm going to stop you here. Over to you. And I think another disclaimer to all the drafting lawyers, you know. So over to you. Would you have anything to add to that? But I will come back to you on that question.
Not really. I think this is a very hard act to follow for me, honestly. So
right.
I'm going to just yield to Dharmendra there.
Would you like to have a shot?
So, just two things. I mean, one, of course, the quality of decision making across the board, except for a few exceptions, has generally been, has left us much to desire. And this is symptomatic of judicial decision making. I mean,
Right.
with all due respects. And what that leads to is the quality of lawyering also being the same, the quality of teaching also having an impact, the quality of our textbooks also having an impact. If we don't, at its foundation, you know, give out those values to our law students, and then it, you know, has some kind of a effect all the way up the chain, I think that's something that probably is not happening.
Right.
The second thing that I wanted to say was I practiced before the NCLT in Bangalore and CLAT in Chennai predominantly. It's close to impossible to assume that some of the members or judges will know some of the most basic concepts of company law. So a lot of lawyering is spent in telling a judge, please see section so-and-so.
Right.
Please see the definition of so-and-so. This is how you start. Then this is where you go. And then you come back to what your main point is.
Right.
And I think that basic and foundation, I don't know if it's about judicial training or if it's something else. I'm sure there are lots of training institutes that train some of the members, but something is missing. And that's a rule of law issue as well.
Understood. Right. I think another disclaimer for judicial members as well. Right. So I think the points that have come across is one is, as you very rightly said, ma'am, the number in the tribunals. The second is the lack of diversity. And ironically, these are places where ESGs, where governance and societal, you know, inclusion is one of the points. That's the other one, the time limits and how you just don't know how long it's going to take, and how it starts from the classroom where, you know, perhaps we are not giving as much focus all the way to the judicial officers who may not, as you have picked up, be able to understand some of the let's go with nuanced, things about the legal provisions. But my question to all of you is that if there was one cultural change, either through an academic lens or through a practitioner's lens, that one cultural change that you would like to see, what would it be and why? You've raised some things, but I want you to narrow it down to that one thing. So by the end of it, we've got 5 concrete things which we can take maybe for the next edition in that. And this time I'm going to begin with you, Saranya.
Okay, thank you. So I think I don't mean to harp on the fact that there is a need for finishing school, right? When you learn corporate law in law school, and then when you're asked to talk about CPCS, and you're like, what is that? Because I never studied it in law school. But it is nothing but just a transaction documentation term, and a term for conditions precedent and conditions subsequent. And the whole concept of signing, closing, all of that, which is extremely basic, but you never taught it as a part of your corporate law because it is not a part of your statute, right? And it is something that has an overlap with your Contracts Act. So I think the need to have the cultural change would be to have something in the syllabus which prepares you. It could be an elective because not everybody would be looking at corporate law, but yeah. So I think with that, over to you, Siddharth.
No, no, no. No, I just, I mentioned it, I don't know if I mentioned it in the introduction. Not everything that can be learned can be taught.
Absolutely.
Right? I think that is very important to keep in mind. So, not taking away from what you're saying, Saranya, I think much of that problem that Akila might face, I faced it also, in that we get graduates who come into the profession simply not being able to understand even some of the basic stuff, is I think, essentially, 3 points that are involved. Very quickly. Quick one. A doctrinal approach, principles, first principles. First principles, sorry.
1A, 1B, 1C.
First principles supported by judicial precedent and statutory interpretation. That's absolutely essential, right? To understand corporate law, more than just company law. And that's the next point, which is that you have to teach or look at the teaching of aspects of other cubbyhold laws into this. You can't teach securities law separate from company law anymore, right? You can't teach, principles of competition law separate from company law. There's several such things, right? And I think the last one, and I'll stop at that, is the classes must have problem-solving exercises.
Right.
If management schools can take on case studies as being the principal means of preparing someone for a future profession, by the way, why can't we do that in law school as part of a corporate law course which has securities and other things, and do it through an entire way of case study analysis and problem solving?
Right.
That I think will solve many of the problems of this issue. Absolutely. Inherent in this, you get you get a structure, and you get students who may want to join the profession, and you'll have very good material going back into academia, saying I want to contribute to corporate law academia.
Right.
Thanks.
Thank you, ma'am.
I think your question was on the culture. What can we contribute or change about the culture in the practice? Speaking as a corporate law practitioner, one thing I would like to see more is what Saranya also mentioned in the beginning of the conversation about commercial savviness and being deal constructive. So the culture we have today when we negotiate commercial transactions, whether it is an acquisition or a merger, is a little adversarial sometimes,
Right.
where people start getting very invested into the document they have drafted and forget that there is a deal to be done, clients who want to make money on the deal and go home. So the culture I would like to see more, and I think it comes with maturity and age, and I see it in lots of times, but I do not see it sometimes, is people who are not who think about the deal rather than their own drafting or their own points of view and stuff like that. A related point I also think is that in India, especially when you practice, we do not have very standard documentation. So lots of times when I start a transaction, I ask who's the other side law firm. Because if it is a good law firm or somebody I believe is good, then the document will be good and will be more towards the market practice and standard. But unlike in other jurisdictions, which I believe, they have standard forms for if it is a business transfer, that's only this much you need to negotiate. You don't need to spend days and days negotiating. But in India, unbelievable the number of days we sit and negotiate a transaction document, which the market practice is very well set. You're not doing it for the first time. It is very, very run-of-the-mill, no rocket science. But the culture is to sit and hammer down those clauses because people are invested in the document rather than the deal.
Absolutely. Thank you very much, ma'am.
Two cultural changes.
1A, 1B.
First one is less procedure, right? I think like taking from where Akila had mentioned earlier, we have too many procedures for our business houses to follow for very simple things. So we should definitely culturally cut down on a lot of procedure, cut down on a lot of regulation, which is absolutely unnecessary, number one. Number two is diversity. Now the Companies Act 2013 has mandated one woman. I think they should make it a percentage of the board. We need more women on the board. We need more women on the bench. We need more women lawyers in corporate law, both in transaction as well as in litigation.
Absolutely, thank you.
Just one suggestion from me was should probably have law firms going back to the law schools and either in tandem with professors immediately as a concept is taught, explain to them how it works out in the real world.
Yeah.
Or do it, if not synchronously, asynchronously, because this happens a lot perhaps in different jurisdictions where an actual transaction is brought to a law school clinic by a practitioner, and they have about 10 law students who are interested in the area sit and learn how that work is to be done with that practitioner. So maybe something, I don't know, I mean, I'm sure confidentiality concerns can be taken care of by just an NDA, but still, that'll be a great way for us to pass on our practical knowledge to the students.
I think that's very useful. That's, yes.
Very short point, very short point. It's just, I think, one more thing, which, I mean, with the wisdom of everybody that I heard right now, is being aware of what's happening. Because while statute may be one thing, there are a lot of times there are informal guidances by SEBI, right? There are case laws happening. So you can't just be like, I know the law because I know the section. Right. You need to really keep up and know what's happening, like what's happening with Gensol right now, what happened with Byju's right now. They're all case studies, and I think it just brings back to the point that you need to be aware of what's happening around you beyond the book. So yeah.
I think that's the beauty of having a very diverse panel, because we've learned things right from law school all the way to practice. So thank you very much. I am going to shut up momentarily and I'm going to move to the audience in case you have any questions. Aditya, please.
It was a very enlightening discussion. And first of all, I'd like to allay the misconception around my alma mater, Cambridge. There's a beautiful course on corporate law, rather a master's in corporate law, which I had the privilege of doing, which selects only 25 students all over the world. And exactly the way it's taught is how the panelists described it, that there are industry experts. We have the magic circle firms, the Hogan Lovells and the Baker McKinseys, taking us through all the transaction documents. So the days of Palmer and Garber, they are done away with. They are now like referring to Malin and Sheffens. And what Avtar Singh does is it beautifully weaves a narrative around the statutory interpretation of company laws in India, weaves in the case laws that we need to study, the important English case laws, and in a way puts it beautifully as to how a student or a practitioner would be able to understand the law.
Absolutely.
Coming to that, alluding to the issues that were discussed, when it comes to the overarching framework of the company's legislation, I had a suggestion that couldn't we have a law, or basically the regulations that are attending to the company's law, that have more room for self-regulation for the companies. Because when it comes to decentralized autonomous organizations, when it comes to DLT-based registries, which are now organizations where there's no statutory framework to govern them. So if, and there are sector-specific regulators laying down the rules for these particular organizations. Like for instance, the RBI has done it for the fintech companies, the regulatory sandboxes. So can't we have that framework by way of rules with the company legislations?
Would you like to direct it to one of the panelists, or would you
so
let them choose?
Akila could answer.
Yes.
So I think, Aditya, after Satyam, we have been on a reverse overdrive. So if you look at our legislations and rules and regulations, both for listed and unlisted, pre-Satyam and post-Satyam, they're two separate worlds, right? So I don't think we're ever going to go back to a more liberal regime. And if you look at our corporate governance principles for unlisted companies, it's one of the most onerous in the whole world. So, and a genzol happens despite this regime. So, I am not very optimistic about further liberalization in the regime, but I completely, second Haripriya's thought about, making it simple. So, and straightforward. So nobody, we send stuff to MCA. For example, auditors, when they discover fraud, they write to the MCA. Till today, nobody knows what happens to what they write. So because there are so many forms that MCA receives, so MCA doesn't read most of the forms. If you can just reduce the number of forms that go to MCA by 1/10, maybe they will read. Similarly with RBI, similarly with the annual report. Our annual reports are bigger than this book sometimes. So no investor is going to read it because the disclosure, tick the box, annexures. So there's just no simplicity in the way we are doing business or conducting a business. So maybe I'm all for simplicity, but not for self-regulation, which is very dangerous given the kind of players we have. So
to tread softly, would anybody like to add? Okay. Any other questions? Yes. I think they'll be directed.
No, two. I had generally two questions, one for the panel and one for the authors. The one for the panel is this, that as a practitioner in court, I've noticed that it's the judgments that we have on company law are few and far between. I'm saying final judgments, not these interim orders with guys standing. Final judgments weighing in on the policy of company law, etc. So there are like a few, Shanti Conductors or Needle Industries, and maybe a half a dozen others, which is, in my view, extremely modest considering how much there is of company law and everything that arises. While after the IBC came in, we're just flooded with case law, right? There must be like 80 major judgments in the last 8 years. What do you think explains that kind of disconnect? That's question one, that's for the panel. Second question for the authors is that when you approach the book, I mean, you must have seen that there's 9 volumes of Ramayana or whatever else it is with forms and blah, blah, blah. Now, that's what Avtar Singh is up against. Sure, you have to keep yourself brief, precise, get fundamentals across. But were there any stages when you were saying that maybe there is something else we should cover and we're ignoring it? And a second subpart, which is, do you think there's some way we can improve company law per se in India? We have a new act, well, it's 12 years old, but we have a new act. Did it miss a trick? Is there something else that needs to be done?
I can take the first question on why we do not have like several Supreme Court judgments on Companies Act. It's because one, most of our commercial transactions are subject to arbitration, and they don't see appeals to the courts. Second, lots of times things don't even go to court. People settle even before we go to court. And third, the documents are drafted by people like us. There are no disputes. So there are 3 reasons why, unlike other aspects of law where people do not go to experts, before doing a merger or an amalgamation, they will go to an expert. So,
Go ahead, please.
Statistic on this: 175 cases of Companies Act 2013 at the Supreme Court, and 380 of IBC. So 9 years, 380, and 175 Companies Act for 12 years. So they're not going up. I'm sure it's because of Akhila, but yeah.
No, so I mean, Akhila, as usual, is astute and absolutely right that it's because of arbitration and other things. But one other consideration is most company disputes are very time-driven. Beyond the point that dispute stops making sense for the company, right? They take a business call whether they want to take it to the next forum or not. The minute they get an interim order from the tribunal or a final judgment tribunal, they don't want to spend another 10 years. So they either settle, they take a business call, and it's a purely business decision not to waste 10 more years. The only law battles, corporate law battles, which go up to Supreme Court are where family disputes are involved or ego is involved. Otherwise, the purely commercial disputes, they're done. They're done by the time they spend the few years.
And Siddharth, if you can club both.
No. I don't know about. I will tell you that the very first transaction I ever did went to court. Okay? And No, hold on.
Personally
I
responsible.
the punchline is to come. No, not that, because our client wanted to basically screw the other client, the other side over and he wanted to prove a point, saying I will, So I remember clearly when we went to Bombay Senior Counsel to brief him because a matter was coming up. By the way, we went to court even though there was an arbitration clause, right? They said, let them unseat us, So we went to the thing, and that's when my senior, standing next to me, briefing him, turned to me and said, now we will see what he has to tell. He says, the buck will stop at me. That's the senior. He says, either that senior counsel will look up to me and say, yes, we've got something to hook. We have some hooks that we can hold on to. Or he'll look at me, and I will look at you sideways, saying, who's the idiot who drafted this? Right? Luckily, it was a former, right? Luckily, it was a former. But it's a nice, funny story, but it's a terrifying thing, because then you realize, could you have drafted something differently? And I asked this question of my colleagues as well. Are we in it to ensure commercial realities are achieved?
Yep.
Or at the end of the day, are we, even though we don't have the court and we're not an officer of the court while we're in a corporate boardroom, shouldn't my first altar be enforceability?
Absolutely.
Right? And that's critical. But at the same time, you do it in a proper way. So, I was like saying, good Lord, if this clause had been drafted differently.
I'm going to stop you there and ask you very quickly, 30 seconds, about the question about the writing of the book of civil material.
Saranya and DC will weigh in on this. That is definitely an issue when we have all those forms and all of it. But one thing was clear. We knew that Ramaya is meant for the practitioner. It's meant to understand, This is a book primarily aimed, as we mentioned in the foreword as well, and one of the things is that it's meant for the junior practitioner and for the student.
Perfect.
Right? So that's really and that is Professor Dr. Avtar Singh, who I never met, by the way.
Right.
It's a very nice introduction from Mr. Datar, who talks about his meeting with Avtar Singh and, from what he did. But so that's the one on that. So there was a thought, but we knew we had to stick to this principle. He had a second question.
You answered the second one. Saranya, would you like to add anything to it in terms of the saving of the materials?
No, not really. I think I would step in and also say that you never think it's good enough, right? So like DC also talked about next edition in the way already. So yeah. So I think it just comes back to that you can never think what you've done is good enough. So yeah.
Absolutely. Dharmendra, any comments on this? Okay, we have time for one more very quick question, no comments. Yes. Just crisp questions.
So we talked about ESG as well briefly. Saranya mentioned about it. So when it comes to India, we only have the BRSR framework. Apart from that, we have nothing when it comes to ESG framework in totality, which might have an impact. So what is it that can be introduced in the company's legislation to strengthen the ESG regime and make directors actually liable for ESG violations?
I think
15
in terms
seconds.
of the statute, you're right. It's only the Companies Act and the BSR report that needs to be filed. But we are seeing a lot of stuff happening on the ESG side when investments happen, especially by private equities and sovereign funds. They require an ESG report. We do an ESG diligence. So India, of course, S and G. G is very strong, as we discussed. S is getting there in terms of our CSR kind of provisions. E is just about catching up. But with the current yo-yo on, whether we are green or we're not green or how cool is green, so it's a little struggling. But there are several private equity funds who are, focused on investing in ESG compliant or ESG conscious companies. And like the Canadian and Norwegian funds are also very, very focused on that. So we do see action around that. But in terms of compliance, not so much.
I think you'd like to add something?
Yeah.
No, I'm good.
Okay. So just another quick point is that unlike the EU, we don't have a consolidated document, which is a point taken. But the thing is, you can't take away the social and employment benefit laws from the S. And they come with a lot of director liability, like under the Factories Act, right? So the whole occupier, can you really get away with that title? So I think there's a lot of law, but it's not consolidated like you have the labor law. You also have something like the fire NOC, which has become the new age thing. You will never really let it go if there's no fire NOC. So so I think in that sense, there are those aspects definitely to be considered.
Any other, DC? I think His Lordship has a question.
Hello, it's not a question actually, it just struck me. Saranya just now said DC, and then it struck me. I do not know whether Chatur is the family name or an adopted family name. Now, obviously the parents, they educated him in law with the surname Chatur, and suddenly all that has been, made into nothing by Saranya saying DC. So it just stuck me, So.
Thanks. Thank you, ma'am. So we will reinstate the name as Mr. Chatur. I think I'm going to take, okay, last very quick question. Very quick and very quick answers.
ESG is to be linked with the CSR. So if I can just
Can be.
that.
Corporate social responsibility, we see it as S as well, whether it is... No?
Not.
Okay, we'll debate this in some time. But I'm just...
Elaborate. Happy to hear your thoughts.
Later.
Yeah. Okay.
We'll elaborate later politely. I think we are very much out of time, so I'll just thank you very much to all the panelists. Round of applause for them, please. And to the moderator. No, I think I'm just going to, Shakespeare once said that my words fly up, my thoughts remain below, and my words without thought never to heaven go. So I think it is time to implement all those things and to make use of this book. I think Sir started with two things about a lawyer. The first is where to find a law and to think like a lawyer. I think at least we've got the answer to one with this book as to where to find the law. So thank you very much.
Thank you, everyone. I have never seen a panel discussion this engaging and fun on company law. So thank you, everyone, for that. And now I would like to request Mr. Siddharth Raja to share some concluding remarks. On the event.
No, sorry. No, I don't know where that came from, but no, thank you. Thanks all for being here. But I'd like to end actually perhaps by mentioning that if there is a set of people who stand out here for their persistence in getting this through, it must be the team at EBC, right? And we must give them due credit for it. Sumit and the others. I mean, we start Niloufar and all of them, because. We started this, yeah, absolutely. Yeah, Niloufar, and we started this effort I started it off just before the COVID pandemic, and we are here 5 years later. And truly, I mean, this needed to get across the line. And if it hadn't been for the persistence of the team at EBC, Niloufar and the others, and of course Sumit and the team, and consistently keeping an eye on the book, I think it's really a testament to the strength of the institution that EBC has become and continues to grow. So just to say that, and thanks, I'll say it on behalf of Saranya, Dharmendra, right, and myself, that years to more. I think he said it well, and that there is certainly, we were always talking about how it's a job half done, which is a job well begun, which is half done. So we'll take that hopefully in the years to come ahead. Thank you.
Thank you so much. As we approach the end of this event, I would like to invite the editor of this book, Ms. Niloufar Bateja, Senior Associate Editor, to please deliver the vote of thanks.
Cicero once said, "Gratitude is not only the greatest of virtues, but the parent of all others." With that in mind, I want to take a moment to express my heartfelt gratitude to everyone who made today so special. As someone who has worked on this book in a very small way, it has been humbling, especially since, like many of you, even I have studied this text in law school. The feedback and the messages that we received reminded us how significant this book is. Some called it the corporate law Bible, others a cornerstone, and it truly is both. A big thank you to Mr. Siddharth Raja, Mr. Dharmendra Chatur, and Ms. Saranya Mishra for taking on such a massive project and doing justice to its legacy. And we hope with the upcoming editions, this legacy will carry on. To our esteemed guests, Justice Hrishikesh Roy, Ms. Haripriya Padmanabhan, and Ms. Akila Agarwal, thank you for your time and insights. And also to Mr. Vishwajit Chaudhary, thank you for leading a fantastic panel discussion. I am grateful to the organizing team, Ms. Prachi Bharadwaj and Ms. Diksha Dabas, who planned everything meticulously. Also to Ms. Kriti Kumar, Shubha Venkat, Tejaswini Mishra, and Sonali Ahuja, who made sure that everything carried out smoothly. A big hand of applause for them. And finally, thank you to all of you here today. Your presence and energy made this evening truly memorable. Thank you and have a wonderful night.